Imagine a city uses a standard, a written exam to hire its firefighters.
Right.
And the test is completely neutral on paper. Like anyone can register, anyone can take it. But the results come back, and the test completely wipes out an entire racial demographic from qualifying for the job.
Wow, yeah.
Like, not a single person from that group passes. So, is that exam unconstitutional?
Well, under the strict text of the U.S. Constitution, the answer is usually no.
Wait, really? No.
Yeah, no. I mean, unless you could prove the city designed that test specifically to weed out that demographic, the disparate impact alone doesn't actually violate equal protection.
That is exactly the kind of counterintuitive legal mechanism we're decoding today. So welcome to this deep dive.
Glad to be here.
Today, we're taking sources drawn from legal lore, mastering the multi-state bar examination, alongside a highly detailed constitutional law prep masterclass script, and we are diving deep into the equal protection framework.
It's a huge topic.
It really is. Our mission today is to look at exactly how the government legally sorts and categorizes you, the listener.
Right, because we're not just having a broad philosophical debate about what fairness means here.
Exactly. No, we are analyzing the highly rigorous, mechanical system of judicial scrutiny, the rules that dictate exactly when the government can treat different groups differently.
And, the foundational concept to grasp here is that every law, by its very nature, discriminates.
Right.
Like a speed limit discriminates against fast drivers.
Sure.
A medical licensing board discriminates against people who haven't gone to medical school.
Makes sense.
So the Equal Protection Clause isn't designed to stop the government from classifying people. It's designed to determine which classifications are actually constitutionally permissible.
Okay, let's unpack this for a second with an analogy. Think of government laws like a bouncer at a club.
Okay, I like that.
Equal protection rules dictate when the bouncer is allowed to have a VIP list, when they can enforce a dress code, and when their sorting methods are just entirely illegal.
That's a great way to look at it.
Yeah.
And to set the stage for your bouncer analogy, we first have to identify who is actually doing the sorting.
Right. Which government?
Exactly. If a state or local government passes the law, the 14th Amendment applies directly.
But if the federal government passes the law, it gets a bit more complicated, doesn't it?
It does, yeah, because the 14th Amendment explicitly only applies to the states.
Right.
The federal government is governed by the Fifth Amendment, which only has a due process clause. There is no equal protection clause in the Fifth.
Which is wild to think about. But the sources touch on this, and the legal workaround they came up with is just fascinating.
It's very clever.
Yeah. The courts basically realized it would be completely absurd if the Constitution banned states from operating segregated schools, but, permitted the federal government to operate segregated schools right in Washington, D.C.
Right, that would make no sense. So the Supreme Court used this doctrine called reverse incorporation. They essentially read equal protection principles backward into the Fifth Amendment.
Just patched it right up.
Exactly. It was a structural fix.
Yeah.
So whether it's the federal government under the Fifth or a state under the 14th, the judicial mechanism, the engine of it, remains largely the same.
And it runs on these 4 steps, right? Finding the government action, identifying the classification, picking the tier of scrutiny, and applying the burden of proof.
You nailed it. The courts approach this through a tiered system of scrutiny. You can kind of visualize this as different lenses a judge looks through depending on the trait the government is using.
Okay.
If the trait is historically suspect, the judge uses like an electron microscope.
Very intense.
Right. But if it's just a routine economic policy, the judge looks through, the wrong end of a pair of binoculars.
I love that. So let's look through that electron microscope first.
Okay, let's do it.
This is the highest level of judicial review, the final boss level, strict scrutiny.
Yes, strict scrutiny.
This tier is triggered when the government uses what they call a suspect classification, so primarily race and national origin.
Right. And it's also triggered if the government distributes a fundamental right unequally.
Like what?
Like the right to vote, the right to travel between states, or, access to the courts.
Okay. So when a law triggers strict scrutiny, what actually happens in the courtroom?
The entire dynamic shifts. It completely flips. Normally, a citizen challenging a law has to prove why the law is invalid.
Sure, you're the one suing.
Right. But under strict scrutiny, the burden of proof shifts entirely onto the government.
Oh, wow.
Yeah, the state's lawyers have to walk into court and prove that their law serves a compelling governmental interest.
And compelling doesn't just mean, hey, this is a pretty good idea, right?
Not at all. It doesn't mean a convenient interest or like a financially beneficial one. It means an absolute undeniable necessity, a matter of life, death, or, state survival.
But proving that compelling interest is only half the battle, right? Because the sources heavily emphasize this narrowly tailored requirement.
Yes, the narrow tailoring prong.
The government has to prove that it couldn't have achieved its goal using literally any less discriminatory alternative.
And that is exactly where laws go to die.
Really?
Oh, yeah. Even if a judge agrees the government's goal is compelling, the law will be struck down if it is over-inclusive, meaning, burdens more people than necessary.
Okay.
Or if it's under-inclusive, meaning it fails to regulate everyone who contributes to the problem.
So it has to be a perfect fit.
Absolute perfect.
Yeah.
Because of this, when strict scrutiny applies, the government almost always loses.
Okay, here's where it gets really interesting, especially applying this to race.
Yeah.
The text mentions that any racial classification triggers strict scrutiny. Any of them.
That's right. Every single one.
Including what lawmakers might call benign classifications, like race-based affirmative action designed to remedy historical discrimination.
Yes.
But wait, so a policy intentionally trying to help a marginalized group is treated with the exact same level of constitutional suspicion as a policy designed to hurt them?
Yes.
How does that make sense?
Well, what's fascinating here is that the Supreme Court's underlying philosophy is that any time the government sorts its citizens by race, it is just inherently toxic to the constitutional order.
So race is just race, regardless of intent.
Exactly. The courts operate on the premise that they shouldn't be in the messy business of subjectively evaluating the motives of a legislature, like deciding which racial classifications are good and which are bad.
Oh, I see.
So by forcing all racial classifications through that exact same filter of strict scrutiny, the judiciary basically ensures that race is only ever used as an absolute last resort.
Okay, that structural rigidity does make sense when dealing with race. But the sources outline another category that triggers strict scrutiny, and this one has, like, these mind-bending loopholes.
Alienage.
Yes, alienage. Laws that discriminate against lawful non-citizens. And the rules suddenly splinter depending entirely on which level of government is making the rule.
Right. Alienage reveals this really deep connection between equal protection and the separation of powers. So when a state government discriminates against lawful non-citizens,
Like giving them different rules.
right, for instance, by denying them welfare benefits or professional licenses or financial aid, the courts treat that as a suspect classification.
So the state gets hit with strict scrutiny.
Exactly. The state gets hit with strict scrutiny, and the state usually loses. Because lawful non-citizens pay taxes, they contribute to the state's economy. So shutting them out of state benefits is viewed with extreme suspicion.
But if the federal government passes the exact same law, say Congress decides to restrict federal Medicare benefits only to U.S. citizens, strict scrutiny does not apply.
Not at all.
The federal government receives highly deferential review and almost always wins.
Right, and the rationale hinges on the Constitution's enumerated powers.
Oh.
The Constitution explicitly grants Congress the plenary or absolute power over immigration and naturalization.
So the federal government basically has an all-access VIP pass to make rules about citizenship because immigration is their territory.
That's a great way to put it.
But if a state tries to play bouncer, they get heavily scrutinized unless, and this is the twist in the reading, unless they are literally hiring the state's bouncers, like police officers.
Yes, I love that analogy. You're talking about the political function exception.
Right.
If we connect this to the bigger picture, it's all about democratic self-government. A state gets to define its own political community.
So that they to drop the standard of review.
Exactly. If a state requires U.S. citizenship for a role that is core to democratic self-government like police officers, public school teachers, probation officers, it drops from strict scrutiny down to rational basis review.
Because they exercise state power.
Right. A state cannot deny a non-citizen the right to earn a living as, like, a barber or a lawyer. But a cop exercises the coercive power of the state. A teacher shapes the civic understanding of the state's future citizens.
So the courts give them leeway there. Okay, so moving away from strict scrutiny, we step down to the middle ground, intermediate scrutiny.
Yes, middle tier.
And the primary triggers here are sex and non-marital birth, historically called legitimacy.
Right. Under intermediate scrutiny, the burden of proof still rests on the government, but the standard is, slightly relaxed.
Exactly.
Yeah, instead of a compelling interest, the government must show an important interest. And instead of the law being narrowly tailored, it just has to be substantially related to that interest.
But for sex classifications, the sources highlight a very specific extra demand.
The exceedingly persuasive justification.
Right. That phrase is everywhere in the text. Like, take a state operating an elite military academy that decides to admit only men.
Classic example.
When a woman sues, the government can't just defend its policy by citing historical traditions or claiming, men are generally more suited for combat.
No, because that exceedingly persuasive justification standard was specifically designed to root out laws based on archaic stereotypes.
Ah.
Like if a state assumes women are naturally better caregivers and passes custody laws favoring mothers, or assumes men are the primary breadwinners and passes alimony laws favoring women.
Those laws fail.
They fail instantly. Intermediate scrutiny demands that the government's justification reflect real, verifiable differences, not just lazy societal assumptions about what men and women usually do.
Which raises a practical question. I mean, does a physical or biological difference ever count as an exceedingly persuasive justification? Or are the courts purely just hunting for stereotyping?
That's a great question. The courts do acknowledge there are physiological differences between men and women, but they scrutinize the government heavily to ensure those differences actually dictate the policy.
So you can't just use biology as an excuse.
Exactly. If a state tries to use a biological difference as a smokescreen for a stereotype, the law fails. The connection between the biology and the objective has to be genuine.
That makes sense. And briefly, for the other trigger non-marital birth, the reasoning the sources give there is really fundamentally about fairness.
Yes, fairness and culpability.
Like, if a state passes a law denying inheritance rights to a child simply because their parents weren't married, the state is punishing the child for circumstances entirely beyond their control.
Exactly. No state interest is important enough to justify legally penalizing a child for the actions of their parents. It's just unfair.
Right. Okay, so if a classification doesn't involve race, alienage, sex, or non-marital birth, we drop all the way down to the residual category, the lowest tier, rational basis review.
The government's home court.
Yeah, the government's home court. The triggers here are age, disability, wealth, and pretty much the vast ocean of ordinary economic and social regulation.
Right. And under rational basis, the power dynamic in the courtroom flips completely.
The government doesn't have to prove anything, do they?
Nothing. The burden of proof rests entirely on the challenger.
Wow.
To win, the challenger must prove that the law is not rationally related to any legitimate government interest.
And the sources make it clear just how overwhelmingly difficult this is. The law doesn't have to be well-crafted. It can be wildly over-inclusive or under-inclusive.
Right, doesn't matter.
The legislature didn't even need to have a specific purpose in mind when they passed it. If a government lawyer can stand before a judge and literally invent a conceivable, legitimate reason for the law after the fact, the law survives.
It is the ultimate deference to the democratic process.
Okay, so what does this all mean for the average person? Like, if you're a 64-year-old and you're mad about a city giving a transit discount only to residents over 65,
Okay, yeah.
you basically have to prove to a judge that there is zero conceivable logical reason for that 65-year-old cutoff.
Yes.
That sounds nearly impossible to win.
It is nearly impossible.
Yeah.
And you're exactly right. If the courts applied strict scrutiny to age, think about what would happen. Every driving age limit, drinking age, mandatory retirement policy would face endless litigation.
Oh, the courts would be completely paralyzed.
Right. They'd be permanently bogged down, deciding whether 16 or 17 is the perfectly tailored age to drive a car. So courts use rational basis to avoid micromanaging everyday life. It ensures judges don't act as, like, a super legislature.
But there are a couple of crucial exceptions here. Wealth alone is not suspect unless it intersects with a fundamental right.
Like voting.
Right. A poll tax requiring payment to vote triggers heightened scrutiny.
Exactly.
And then disability. Disability gets rational basis, but the courts apply it with teeth, right?
Yeah. So if a city uses zoning laws to block a group home for people with intellectual disabilities from opening, the city might claim, oh, we're just preserving the character of the neighborhood. But if the evidence shows the law was actually driven by irrational prejudice or neighborhood panic or pure animus, the law fails even this lenient test.
Because you can't just pass a law because you don't like someone.
Exactly. A bare desire to harm a politically unpopular group is never a legitimate interest.
Okay, so this entire tiered system relies on identifying the trait the government is using.
Right.
But that brings us back to the massive curveball from the very beginning of the episode, the firefighter exam. What happens when a law doesn't say it's discriminating, but it totally does in practice?
Ah, the ultimate trap. Facial classifications versus disparate impact.
Right, because a facial classification is obvious. Only men may apply. You instantly trigger heightened scrutiny.
Right, no separate proof needed.
Hmm.
But a facially neutral law with a disparate impact, like that written city exam that disproportionately excludes one racial group, only gets rational basis review by default.
Which is crazy to think about.
It is.
To trigger heightened scrutiny for a neutral law, the crucial catch is that the challenger must prove discriminatory purpose, intent.
Yes, intent is everything.
The law must have been adopted because of, not merely in spite of, its adverse effects.
That distinction is the heaviest burden in constitutional law.
So let me push back hard on this. Wait, so if a city's written exam completely wipes out an entire demographic from getting government jobs,
Yeah.
but nobody sent an evil email or explicitly said, we're doing this to keep them out, it is totally fine under the Constitution.
Well, this raises a really important question because we have to clarify the vital distinction between constitutional equal protection, which demands actual intent, and statutory civil rights laws.
Oh, like Title VII.
Exactly. Congress passed statutes like Title VII for employment, which might offer remedies for disparate impact alone. So you could win a lawsuit under Title VII without proving an evil email.
Okay, I see.
But under the Constitution, the Equal Protection Clause demands a showing of actual intent. You have to prove they did it because of the impact. And you prove that via lawmaker statements, suspicious timing, or historical background.
Which is incredibly hard to find.
Almost impossible.
So, bringing this all home for you, the listener, understanding equal protection means understanding that your rights often depend entirely on which bucket the government places you in.
Absolutely.
Knowing who bears the burden of proof, you or the government, is really the secret to understanding why some laws survive and others get struck down instantly.
It dictates the entire strategy of constitutional litigation. And, I'll leave you with a final sort of mind-expanding concept that builds perfectly on this intent requirement.
Okay, let's hear it.
As governments increasingly rely on AI and algorithmic risk assessments to distribute resources or, make zoning maps, these systems often create severe disparate impacts based on race or wealth.
Because they're trained on biased historical data.
Exactly. But if an algorithm wrote the policy, how can a citizen ever prove discriminatory purpose?
Oh, wow.
Right? Can a machine have an intent? If equal protection requires a human because of motive, are we prepared for a future where discrimination is entirely automated and perfectly facially neutral?
That is, wow, that is a perspective that completely changes how you view the future of government regulation. Something to definitely mull over. Thank you for joining us on this deep dive into equal protection. We'll see you next time.